Now, to discuss about the elements of criminal conspiracy, we have to first discuss that there are two types of criminal conspiracy. One is unlawful means conspiracy, and two is lawful means conspiracy, and each of them have different elements. One, for the unlawful means conspiracy, there must be four things present: an agreement, intent to injure, act carried out in accordance to agreement, and actual harm as a result. For the first element, it involves an agreement between two or more individuals, which can be informal and inferred from circumstantial evidence such as text messages, something as simple as a text message or an email. Second element is intent to injure. The intent to harm the claimant is implied when with unlawful means such as fraud or deceit are used. That's what makes this type of conspiracy unlawful, even if harm was not the primary intent. Third element is act carried out in accordance to the agreement. The act must align with the conspiracy's goal. So, if the ultimate goal was to murder someone, then the acts leading up to the point of murder must be consistent, and it does not matter. And then, moving on to the punishment under the Penal Code. Punishment for criminal conspiracy can be found under Section 120B of the Penal Code, and it stems into three. For serious offences, if conspiracy involves crime punishable by death or imprisonment for 2 years or more, the punishment matches that abating the offence. 2, for lesser offences, imprisonment for up to 6 months, a fine, or a combination of both. And then 3, for minor offences, punishment is limited to the maximum penalty specified for the minor offence under the Minor Offences Act 1955. Now, I'm going to pass the mic over to the next presenter.
The fact of the case is, in between April 3rd and April 24, 2015, the accused held meetings at restaurant Mahi in Serdang and the second accuser's house in Hulu Langat, where they discussed about topics such as jihad, the Syrian conflict, and the Islamic State, which is IS. So, items found in their possession, including the ammonium nitrate, batteries, wires, PVC pipes, and tools that can link to bomb making, with other witnesses possessing diesel, fuel, matches, and also aluminium foil. So the defense argued that their trip to Gunung Nuang on 2015 was just for a recreational camping, denying the involvement in the terrorism, and claiming the bomb-making discussion were initiated by another party and not acted upon. So specific defenses included denying possession of ammonium nitrate, claiming the material were carried unknowingly, and justifying diesel as just for the campfire. However, the prosecution countered with evidence of bomb-making discussions and materials, strongly suggesting the accused were engaged in a coordinated conspiracy to commit acts of terrorism. Okay, I will summarize the fact analysis. So this case highlights the essential elements of criminal conspiracy, which involve multiple individuals, shared agreement, overt actions, and a continuous offense. So between April 3rd and also April 24, 2015, the accused held meetings discussing plans to target entertainment venues, gambling establishments, and test bombs, demonstrating a collective intent. Actions like acquiring bomb-making materials and planning tests at Gunung Nuang moved the conspiracy beyond discussions into active preparation. The discovery of IS-related items and bomb-making tools further supports their intent to commit terrorism. The sustained planning and coordination over weeks confirm the deliberate and ongoing nature of the conspiracy.
Okay, now let me quickly explain the main points from the High Court and also the Court of Appeal. So the focus of the law in this case is about a conspiracy, which is under section 120A and 120B for the punishment, and then also promoting terrorism, which is under 130G. The prosecution showed that the accused planned the criminal acts like making the bombs and targeting the public places. Witnesses and evidence supported this thing, and also all of the elements were established in this case. Even the fifth accused, when during the capture, who did not have the materials, was found guilty because they agreed to join the plan. The court decided there was enough proof for all of them, and because they disagree with what was held in the High Court, they decided to appeal. Court looked at a small mistake in the testimony but say they did not really matter. They also confirmed that you don't need to commit the crime. Just agreeing to it is enough to prove the conspiracy. Therefore, the defense did not hold up, and the sentences were mostly keep the same, except for the accused one and the accused two, which got their jail time reduced from the 20 years from the 25 years. So, for the health analysis, in our view, the trial judge correctly established the accused conspiracy to commit terrorism under section 120A, 120B of the Penal Code, and appropriately apply Section 130G for promoting terrorism. The evidence of bomb-making preparation and plans to target the public places strongly support this conclusion. We also agree with the Court of Appeal decision to dismiss the defense argument regarding the missing witnesses. The evidence presented was robust and sufficient to prove the case, rendering Section 114G of the Evidence Act inapplicable. On sentencing, the trial judge rightly prioritized deterrence, particularly the accused 1 and 2, given their leadership role in the conspiracy. However, we feel the Court of Appeal reduction of the sentencing while ensuring the consistency risks undermining the intended deterrent effect. Sentencing must balance fairness, the seriousness of the offence, and also the implication of this national security. So, in the conclusion, this case underscores some important principles about conspiracy laws, sentencing, and national security. Let me summarize the key takeaways. First, criminalizing intent and planning. Under Section 120A, people can be punished just for planning a crime, even if it does not happen. This is crucial to protect the national security for whatever future offence that are going to be committed. So, second, sentencing challenges. The Court of Appeal reduced some sentences from 25 to 20 years for the appellants A and B. While it aimed for consistency, it raised concern about fairness in handling serious cases like terrorism. Finally, the importance of conspiracy law. Imagine even planning or coordinating an attack is a serious crime. This shows how essential preventive law are for national security. That's all from our group about criminal conspiracy topic. Thank you very much.